Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I'm your host, Maryann Petri, and there is going to be a non-denominational retreat weekend at the Resolution Center of Jacksonville, Florida. This will be a time of support and renewal for parents and grandparents on the journey of parental alienation. It's called Standing Strong in Resilience, Paving the Way for Good Health and a Great Future. This will take place April 22nd and 24th, 2022, and I will put all the details in the podcast notes. I welcome Attorney Leslie Ferderigos. She is from Chicago, Illinois. She grew up in Orlando, Florida, where she currently resides with her husband, also an attorney, Michael Ferderigos Esq, and her 4 children. Leslie is licensed to practice law in the state of Florida and United States District Court for the Middle District of Florida, and is a proud member of the Florida Bar, Florida Justice Association, Central Florida Trial Attorneys, Civil Trials Section of Florida Bar, Elder Law Section of the Florida Bar, Family Law Section of the Florida Bar, Health Law Section of the Florida Bar. Leslie's practice areas include high conflict family law issues, parental alienation, dependency, and DCF issues, injunctions, guardianships. Leslie is also a regular guest speaker around Florida with the National Parents Group organization. She has appeared on NBC and ABC News on selected cases. Leslie's passion is in trials and has handled over 200 evidentiary trials and hearings since she has started practicing law. And we have a lot to talk about, all her things about her cases. And I welcome you to my show, Attorney Leslie.
Thanks, Maryann.
So in your travels, you see that what parents do that can ruin their case and keep them from seeing their kids. That's probably a big thing that you see the most, do you think?
Yeah, definitely. Sometimes the emotions are at such a height for us. And I say us because I also was an alienated parent, and that's why I chose to become a lawyer. You get really wrapped into the emotion of it, and it's easy, to go on, just go on Facebook and just start posting things, and then the next thing you know, it's used against you, and then the court is, wanting to order you a psychological. I've actually seen that happen in some cases. So there's definitely actions that can be taken, and I think a lot of it stems from impatience, because it's really hard to be away from your children, and the rate of the court system is like snail's pace. And then 2, of course, you're under a lot of stress, so your emotions are heightened.
Mm-hmm. Yeah, it's very hard for parents to understand why this takes so long and why these cases are dragged out. And I'm sure you've seen opposing attorneys file one continuance after another to drag the case out.
Yeah, based on my experience, just kind of giving a roadmap, I have developed a roadmap to where I want my case, like how I want it to progress when I'm representing a case. I give myself little benchmarks. And what I've found is, if you work a case efficiently, by the time you file a petition for, say, modification or dissolution or paternity, you're looking at anywhere from 9 months to 15 months for it to get resolved if it goes to trial. Now, if you settle before, you can finish it quite faster. But if it doesn't settle and you have to go to trial, you're looking at about 9 to 15 months. So I typically tell people, tell clients, when I first talk to them, I let them know the time frame that they're looking at, because it's not something that gets resolved in a couple of months.
Mm-hmm. I've also found that even judges will drag the case out. They'll say, okay, I've issued this, and we'll come back in 3 months and see how things are going.
Yeah, I mean, it's really, it really depends on the judge. Yes, there are some that just don't take the parenting issue seriously, and they'll just put it on the back burner and say, well, my docket is clogged up, I don't have any available trial dates, or I don't have available hearings until 5 months from now. I've had judges say, well, I'm rotating off the bench in December, and say we're in October, they'll say, I'm just going to hold your issue till the new judge takes over in January. So, it's like, it really depends. I mean, however, last week I was in a case management conference, and I explained to the judge that my client had not seen her kids in 2 years. And, this, I had taken over later in this case, but her petition had been sitting on the docket for going on 3 years. And I just took over her case, I would say like maybe 6 months ago. And I explained to the judge, look, this case it was filed almost 3 years ago, and there's no resolution. Now this mom has not seen her kids. And the judge goes, well, I do take parenting issues like time sharing very serious. He said, so let me look at my schedule, and I'll see what I can rearrange to get you in sooner, because at this particular time, the soonest he had was August, and this was last week. So he actually got us in the end of April, which was, faster than waiting till August.
Right. Well, at least he was able to work with you. It's, how would parents effectively work with you to get the most out of, you're representing them?
What I always tell clients is we're in a partnership together, and I pay for software that stores files confidentially. And so I always, when I sign a client up, I always give them access to this online confidential folder. And I tell them, look, I'm going to be making discovery requests on, your ex or the adversarial party in the case, but you also need to get me as much evidence as you have, so that we can build your case. So the best thing that they can do is work on getting me evidence to substantiate their claims, because at the end of the day, that's going to really make a huge difference should the case go to trial. And there's things also when you get evidence to make sure you're getting it properly, because just because you say screenshot something doesn't necessarily mean it's going to be admissible in court. There's standards you have to go by. Authentication, for instance, I give my clients, I'll email them what's called a business record exception form. And I tell them, if you're going to get doctor's records or you're going to get school records, I need you to get this signed by the records custodian at that facility, so we can get it authenticated and into evidence. So their biggest job for me is collecting evidence that they're able to collect.
I'm sure you're seeing like a lot of emails and text messages. That's probably what you're seeing a lot of.
Yeah. Oh, definitely. So that's, it's really, it's so people don't realize how complex law is. It's almost like if you go into, the more awareness you have on something, you're going to look at life differently. You're going to see things differently. It's like a music producer who listens to a song and they hear every note in that song versus the regular person just enjoying that song, and hearing it, on a surface. The same thing is in law. And people get really upset because they're looking, when you're not a lawyer and you haven't encountered the rules of evidence and all these different technical things that go into a case, it's easy to say, oh my God, I got screwed. Why did the judge rule against me? But that little did that person know that there was a lot of technical errors that took place that they wouldn't be aware of, and the reason something didn't get admitted into evidence or whatnot. So that can be really difficult for people, because on the surface, it looks like something anybody can attack, right? Let me pull a statute up, let me do this. And it's so much more complex, so much more, that people do not realize everything behind the scenes to get a successful outcome.
And you just never know if you will get a successful outcome. You could have everything in place, all your ducks in a row, and it could backfire. And then your client blames you. And it goes back to, how do you pick, the right attorney for you? I know I'm throwing a lot at you. I'm sorry.
No, you've got you've got what's called judicial discretion. So there's certain issues that give a judge a large window of flexibility to lean in go on one side or go on the other. An attorney has no control over that. Maybe the judge doesn't like your client, and it's like there's only so much you can really do in those circumstances. When they have that judicial discretion, they can go either way, and there's nothing an attorney can do about it when that discretion is given to a judge.
Definitely. I mean, I could see that in my situation as well, that there was nothing my attorney could do. Like you can see, and I think any parent can see that, oh, this is out of our hands completely. And not to blame the attorney. It's the judge who's the problem.
Yeah, well, I'll go ahead and say this because I think it's relevant. And to Maryann, it's going all over the internet. I'm being attacked with it, so it's one of those things I might as well just come out and lay it out there. About a year and a half ago, I was representing, and this goes to the whole idea of judges. I was representing a client. She was getting sick of the fact that her former husband kept making allegations about her mental health and calling her crazy and making all these comments. So she had requested that I file a defamation suit against her former husband because he had gone out on a limb with third parties, voicing these statements. So I filed the defamation suit. Of course, it's not in family court anymore. Now it's in civil court because it's, a different case. And the first day that I went in before the judge on this case, the judge was mad, going, I don't want this case in my court. Why doesn't this case stay in family court? Okay, I just listened and we continued on, and we had maybe 2, and I'm talking 5-minute short discovery hearings that I had the transcripts to, because we never went into a hearing without a court reporter. And we go to a third hearing, like a really short hearing, and we leave the hearing with the judge telling opposing counsel, write up an order and submit it after you get Ms. Ferderigos' approval. So opposing counsel gives me this order. It looked fine. I didn't see anything wrong with it. I said, it's approved. He submits it. Then a day later, a 4-page order came through the docket alleging that I had not complied with the court's direction to take out punitive damages, and now the court was going to dismiss my client's case with prejudice so she could never file it again. So I'm going, wait, we've never had a hearing on punitive damages. That issue has never come up. And I went back and I looked in all the transcripts, and nowhere in there did it come up. So the proper protocol, the professional protocol, is to file a motion for rehearing. I file a motion for rehearing. I attach the transcripts, letting the judge know that this issue has never come up. And on top of it, I was opened up for malpractice because, my client now can't pursue this, and then they're blaming it on me as if I've done something wrong. So I file a motion for rehearing 10 minutes after I filed it, which indicates to me he never read any of the transcripts. He immediately denied it. Then I get mad at this point. Okay, I get mad. So I publish a letter. I call him unethical. I filed in the court docket. I send it to him. I file another motion for rehearing, and I put in capital letters, how is this justice? Well, the judge reported me to the Florida bar for doing that. And after the Florida bar got involved, I sent the judge another letter, and I said, are you sure you don't want to read the transcripts? Because it will validate that your order is stating 3 false statements about me that have never been discussed in any court proceeding on this case. So he ends up reading the transcripts. He calls a hearing. In the hearing, he apologizes and states he made a mistake. He vacates the order, but he never withdraws the bar complaint. So what ends up happening is I end up getting disciplined by the Florida bar for disrespecting the judge. And I'm now on 1 year of probation over this issue. So
Oh,
I'm just, and the problem is I'm also in a huge defamation suit against 13 people who are flying all around the place, throwing this, this discipline out there. And the common people don't read the substance of what took place. So they just automatically go, oh, she's unethical, right? But they don't realize the circumstances that led to that. So yeah, I mean, that's my issue with judges. You are not to question, you are not to put down the judiciary as an attorney, or you will pay the price like I did.
what a shame. I am so sorry.
Yeah. I mean, it's one of those things. It's like, I could understand if I had made something up but this was clear facts that, so yeah, it's sad because as an attorney, you have to be real careful, how you approach the judicial system because you're an officer of the court. So you get a lot more flexibility when you're, just somebody representing yourself. So
it's almost like it kind of is discouraging to become an attorney if this can happen to you.
absolutely. I'll be honest. I mean, I came into this because I was alienated, and honestly, I was sick of paying attorneys. It cost me my whole settlement for my divorce. I never walked away with anything because it all went to attorney fees. And I just finally had enough, and that's why I became a lawyer. But man, oh man, I had no idea all the politics involved. You're very limited with how much you can really advocate on behalf of injustice that you might see.
And we, it's like there's so much that can happen even during a case and during litigation. And, again, how do you avoid falling into a bad outcome? And it's like you don't have any control over anything.
The only thing that you can really do is hang your hat on an appeal, and to try to get it out of the trial court, get it heard, because at least in an appellate court, you're dealing with 3 judges overlooking your case versus 1 judge that would look at your case in trial court. So I always assume when I go into trial, I actually almost write an appeal. And I have a whole structure of what evidence I need to get on the record, what evidence I need to keep out, what case law I plan to argue, what objections I plan to make. Because I go into every trial assuming it's going to be an appeal, because that is honestly the best way to prepare for a trial, hands down. So that's what I do. That's the only thing that I think you really can do. But a lot of people don't have the money to appeal. I mean, it's at least $20,000 on average to get an attorney to take your case to an appeal. Not a lot of people have that money.
No.
So
yeah, that's, you've got a lot of parents representing themselves. Some are successful, some are not, especially when you go to appeal to the higher courts. They usually shoot you down as a pro se.
Well, I mean, appeals are hard enough for a lawyer. That was like the thing, the dreaded thing in law school. Oh God, we have to write an appeal. It's difficult to write an appeal. It's very hard. And to not have the law school experience of how to write these appeals, how to analyze case law, whether or not someone has access. Like I pay every month for a program called Westlaw, and I pay like $600 a month to subscribe to that so that I can be up on all the current case law. But the typical person isn't privy to all of that. So how do you really write a successful appeal when you don't know how to navigate the case law appropriately? And and so it's difficult.
Right. I've also heard it said that when you write your appeal is to talk in normal language and not use case law all the time in an appeal. I don't know if that's true or not.
I mean, you want to break it. I always believe you know something when you can simply state it. So I will simply state things, but I will cite where that idea came from, or that, you know, like I'll always cite. So it's not just my opinion, right? It's I can piece things together at the end and give my opinion, but when I'm arguing a statute and how my client's fact pattern didn't constitute a finding within that statute, I reference law to demonstrate, either by saying how my client's situation is similar to that law or that case law, or my client's situation is different to that. So I use what the appellate court has already ruled on, and I analyze my current case using that sort of case, you know, the case law behind that. But everybody's got different ways of going about it. That's just something, that's how I do my appeals.
Mm-hmm. Well, that's good advice. You know, what can, you know, you as an attorney truly do for your case, and what are limitations that you might experience?
I would say the biggest problem that I see, and I did an interview on this like last week. The biggest issue and the limitation really comes with money, and whether a client has the money, say, for a court reporter, whether the client has the money to send out subpoenas, whether the client has the money to hire expert witnesses to prove this aspect of their case. And I see a huge problem, at least in Florida. I don't know about the other states out there and if this problem is prevalent as much as it is in Florida, but there is a demographic group, and it's usually, I would say, around the $30,000 to maybe the $70,000 a year income, you know, income producer. And they're the ones that really struggle the hardest, I think, with getting effective counsel for their case. The reason I say that is a lot of people under 30,000 can qualify for legal aid, so they can get free counsel just based on the governmental assistance put into place. And then once you get to like, say, like $80,000 and up, you've got some wiggle room. You usually, you know, you bought a house and you got some assets you can pull from, or whatnot. But lower to middle income, you know, citizens are really, they're really at a disadvantage with the legal system when it comes to family law. So, you know, Maryann, I was talking to you earlier that I had come up with a solution to that, and it backfired. You want me to? I can talk about it now, or I can, you know. Want me to talk about it now?
Oh, definitely, because yeah, it involves all of us.
Yeah. So when I first went into practice, being that I had been affected within this particular demographic of people, I thought, what a great idea would it be to put together a hardship program. I don't get state funding, so I couldn't rely on the state giving me money, but I was thinking to myself, a hardship program where people would not have to pay me an upfront retainer, where based on their income, and obviously I'm going to know their income because I'm doing their financial affidavits and everything else, but come up with an agreed upon dollar amount that they can afford to pay every month that I'm representing them. And that way they're not getting hit with attorney bills that they didn't expect, you know, because I'll tell you right now, the typical case, I would say at the very low end is about, if you settle at mediation, you're looking at least $2,500. If you take it to trial, you're looking way beyond that. You're looking at 5,000, 7,000, 10,000, depending on how many days your trial goes for. And the average attorney rate is usually around $300 an hour. Go to Miami and you're talking $500 an hour. So I had these payment plans where people were paying me dollar amounts as low as $300 a month, sometimes $200 a month. I even had people paying me $80 a month. And they would pay that to me, and it would be with the expectation that they would pay me that through every month that I was representing them. And I was truly doing that to help people, but I couldn't do it for free because I have to pay babysitters, for my own kids, and
Mhm.
I'm not getting governmental assistance.
Mhm.
So I was doing this, and I had gotten a lot of, I had to have a higher volume of clients or I couldn't make a living. I mean, I couldn't make a living off $80 a month. You know what
Mhm.
I'm saying? Like, I have bills,
Right.
I have loans I have to pay back, I have operation costs. So I realized that I had to have a higher volume, of client base. Well, I had hired somebody to be, who I actually won her case for and made sure that her kids weren't taken away. I hired this person to be a paralegal for me, and she worked for me for about 4 months. And I noticed she wasn't doing her work, and I questioned her about it. She got angry and she abruptly quit on me. Well, then the next day she calls me back or texts me back. I'm so sorry. Can I get my job back? And at this point, I was done. I said no, because she was really rude to me the day before.
Mm.
So she tried to extort me into paying her $7,000 at this point, claiming I owed her for a gaming computer, that I owed her severance pay. And I didn't owe her any of this. We had a contract. There's nothing like that in the contract. And she said if I didn't pay it to her within 3 days, she was going to make sure she made my life a living hell. And that's exactly what she did. She started going around to adversarial attorneys or clients that I might have had a problem with, that sort of thing, and telling people I was frauding them from allowing them to make payments to me on this hardship plan. And okay, I was taking a loss on these hardship plans,
Mhm.
for what my normal attorney rates would have been. And what she was doing is she was taking a believable situation. Like, we know that the courts go slow. Okay, we know you're looking at anywhere from 9 months to 15 months to get resolution. She would tell people that I was purposefully not moving their case forward so that I could sit there collecting their monthly payments, which was not the case. Because I had a goal to move their case. I'm dealing with people that aren't seeing their children, but some of the people that just probably didn't trust attorneys from the get-go bought into it. So because of all of that, which is really sad, I just stopped. I stopped the hardship program because I was getting accused of frauding. And I'm like, wait a second, I could technically I could ask for a $5,000 retainer up front, and within 12 months of, say, paying me what, $300 a month, wouldn't even pay my initial retainer. You're looking at
Mhm.
what, like $3,500 for the year, if that, wouldn't even pay my initial retainer. So I unfortunately stopped doing that, which is really sad because it
Mhm.
really actually hurts people that I was trying to help. And that's what these people that grouped together and started defaming me. That's why I'm suing 13 people right now. But they ruined it for all the other people that probably really could have benefited from me doing that for them.
That
So
is a shame. It's
yeah.
like no good deed goes unpunished. I don't know why that is. When you go to try to help someone, it just backfires
Well,
in some cases.
well, I think what happened too was a lot of the people that I represented probably had never been able to afford an attorney before. So they didn't recognize what I was doing for them. Now, had they been with other attorneys, they would have been like, "Holy cow, man, she's representing me for $300 a month. Wow, taking this to trial or whatever." Um, so it was. I think a lot of people that just didn't understand how normal attorney fees play out and what's normally expected from an attorney, unfortunately. And then I know that many of these people have never retained counsel after me, because I go in the docket, I can see whether they retain counsel, which is really sad because a lot of
Mm.
people just said, I'm not going to be frauded anymore. I'm going to, you know what I mean? And I'm going, I'm like, okay, go and navigate that on your own. I mean, you would have been in a much better place having attorney representation, but I assure you, I'm not frauding you. I'm like, I'm
Mhm.
hardly making anything from your case.
Mhm.
So
Right, 'cause why would you do that? You're trying to help people who
yeah,
can't afford. You were doing a magnificent service, and then you got treated like this. I'm so very
yeah.
sorry.
No, I mean, it's just, discouraging because I really, thought it was going to be a really good program for people, that would not be able to normally hire an attorney. And I mean, it's just now, now what I do is I still will work with people, but I always tell them, okay, you owe me a $5,000 retainer up front. And any work I do on your case, is added to your invoice. You can make me payments on that invoice to pay it off, each month. You don't have to come out of pocket the whole thing, but it lets them know, hey, look, this is all the work that's been done on your case. This is the value of my service. Where when I did the hardship agreement, I didn't let them know the value of what they were getting. And I think sometimes people just need to see that, so that's how I'm doing. I'm still trying to work with people that can't afford, but I'm doing it that, you know what I mean? I'm tracking everything and
right.
Holding them responsible for paying the total amount. So
I don't think people understand what goes into writing a brief. I hate writing briefs. That's like the worst thing, I think.
Yeah, it's a lot. It's so funny because on my computer screen as we're talking, I've got just 35-page brief. And that is one thing that I do for clients, is, if a client clearly can't afford to come out of pocket $20,000, I work I do it for peanuts for them, because I do believe, like, if they're getting screwed and I've got a solid legal argument, it's like I'm a fighter and I can't just walk away from the fight knowing, oh my God, we're like this close to getting the trial court's judgment overturned. I'll put the time in just because it's principle. I'm not saying I do it for free, but I definitely, do it at a very discounted rate because, I don't want to see somebody not be able to see their child simply because they can't afford it.
Yeah, and it's so sad because, these parents are not in a good financial position, or they've tried other attorneys that they have paid heavy retainers to, and then they're tapped out, and now they're coming to you. Some people cannot go pro se. What is your opinion on pro se litigants?
Some people don't have a choice, but to me, they're usually the ones. Of course, you got exceptions, but they're usually the ones that get really mad and really believe that injustice has been served. But the problem is, like I said before, they're not seeing all the little intricacies. The judge is not going to argue for you. The judge is just there to accept evidence in or accept evidence out, or make a ruling, but they're not going to sit there and tell you how to litigate your case or tell you that your rights are getting trampled. That would disrupt the whole process, right? If a judge were to do that, that'd be bias, and then the other side would get the judge recused off that. So you have to bring everything that you bring into the court is on your initiation. So if you're missing the mark and you get trampled, you're not even going to know it. I can give an example if it helps.
Oh, sure.
So when I first started practicing, I did not really understand how I was going into these hearings for the first time. And all of a sudden, witnesses that I never even knew, would show up in these hearings, and then, or evidence would be, thrown at me that I'd never seen before. And the next thing you know, oh my God, I have to argue this. I didn't understand I was going, this is a bunch of crap, right? Like, how do you prepare not knowing what you're walking into, in an evidentiary hearing or a trial, and all of a sudden you're getting, some witness that gets to come in and basically kill your whole case that you never even knew was coming in. Well, what happened was, after that happened a couple times, and I was furious about it happening, and I was thinking to myself, this has got to be the biggest crock of crap judicial system to allow such a thing to take place, right? I started to research case law on non-compliance with pretrial orders, non-disclosure of trial witnesses, non-disclosure of exhibits, right? And what I learned, and I compiled a whole folder of this evidence. So when I next went to an evidentiary hearing and opposing counsel threw a witness at me that I didn't know was going to happen, and threw a exhibit, some sort of report that I never knew, I immediately objected, and I had all my case law there, and I argued to the court, and I said, look, this is called surprise and fact. This is a denial of due process. I am supposed to be able to have the opportunity to depose this witness so that I can know and fully prepare what this witness is going to testify to. I should have had the ability to look and read over these exhibits so that I could provide rebuttal exhibits before I enter into this evidentiary hearing.
Mm-hmm.
And I would say then the judge would say, well, what do you want me to do, Ms. Ferderigos? And I would say, because I knew the law very well at this point, I would say, Your Honor, the most severe sanction that this court could impose on opposing counsel would be striking their exhibits and witnesses. Thus, I'm not going to put Your Honor in that position to impose the highest, sanction possible. I said, but the most appropriate thing to do in this case is to continue this hearing, allow me the ability to depose this witness, allow me the ability to bring rebuttal exhibits forth, and have this rescheduled. Mm-hmm. And the judge, hands down, none of them could. They did every single time they did that for me, because they couldn't argue. I had all the case law. Now, if you're pro se, you're not going to know to do that. You're just going to enter in. You're not going to know what to argue. You're just going to say, look, I just saw this for the first time. And then, and it's not the judge's responsibility. Some of them might find it to be unjust, and they might say, well, why didn't you, do this or do that? You know what I'm saying? So, but for the most part, those are the little things that I'm talking about that people don't realize when they're pro se. It's the technicalities of the procedure.
Mm-hmm, mm-hmm. Well, I agree. I've been there and done that. And, I see other parents trying to pick out an attorney, and they're looking at, Yelp and looking at how many stars the attorney has,
Don't rely on that. I've got a huge defamation case. And like I said, I was attacked with fictitious names of people that I don't even know, attacked on Google so bad that I had to actually shut my business down on Google, because Google wouldn't take care of it, and I didn't know who these people were. Yeah.
Oh, that's terrible, and that's disgusting to do to someone. And I don't know why people. These false allegations just seem to run wild everywhere.
I'm getting into defamation law, by the way.
Yeah.
I just announced, it was funny, yesterday I just announced that going through defamation myself firsthand, that I will help anybody out there going through defamation, because I am I'm dealing with it personally right now. So. Mm-hmm.
Oh, that's terrible. I'm so sorry. Well, I don't want to keep you too much longer, because I know you've got a lot going on. Is there anything else you'd like to add?
I'm just trying to think, what it is that would be most beneficial for people to hear. And like I said, I asked you your audience before, because I don't know if they're, if most of them are, say, pro se litigants, because I could give some good tips of advice to pro se litigants, or if it's litigants that, you know what I'm saying, that are alienated, that do have attorneys, or whatever the situation might be. What I would, I guess I'm trying to think of the best. I'll give you advice based on, these are kind of standards for anybody, okay? Whether you're pro se or whether you're represented by counsel. The court is going to take time, unfortunately. Like I said, if you're working a case efficiently, you're looking at 9 months to 15 months to resolve a petition before, you could, unless it settles sooner than that. So do not get impatient. And I tell everybody this, because during their case, they're like, I can't take this. He keeps doing this, or she keeps doing that. I haven't seen my kid, this and that. And I say, look, you're involved in litigation right now. Mm-hmm. You're not outside of this little bubble, meaning if this doesn't settle, we're going to trial. And guess what? Do you really want at this point the other side to clean their act up so impeccably beautifully, so by the time you get to trial, you don't have any evidence to try to get a change in what you're trying to get changed, and they look like the good guy, to the judge? I said, you know what, take this moment in time, because it's not going to be forever. Realize it's going to be very uncomfortable. Okay, you're going to be pissed off, you're going to be irate, but remember that this is your time to gather as much evidence as you can, so by the time you get to trial in front of the judge, you show the judge exactly who that person is. And and I said, but you need to have the best behavior you can, because this is the only time this judge is going to see you, and this is not forever, although for some people they're in and out of court for the next 18 years. But I try to explain that to people, because it's really difficult, because the court systems are so slow. So and also recognize that, here's another piece of advice. If you have an attorney and you are past a mediation and you're in what's called the pre-trial stage of your case, do not go changing your attorney. Because if you want resolution, the number one thing that will stall your case, prolong it by possibly 6 more months, is hiring a new attorney when you're in pre-trial litigation. Because at that point, either the other side or your new attorney is going to ask for a different trial date. And that different trial date might not be for 6 months after the trial date that you got. So to me, switching attorneys like that it can really affect the pace of your case. So you want to really put the research in the beginning, so that you can stick with the same attorney, because that is the only way that you're not going to get into all of these, these delays. And make sure that if it's highly contentious and you do not believe there's a possibility of settlement, make sure that the attorney that you hire is a trial attorney who understands how to try cases, understands the rules of evidence, because that is going to be vital in your case if you have to go to trial. So those, like I said, those are the most, I would say, the most important pieces of advice.
Well, I've got a question for you that I promise I'll let you go.
Yeah, no worries.
What do you do with an opposing attorney who just calls out parental alienation on you as a parent?
You're talking about if they reverse it and then I'm now dealing with the allegation?
Right. Like the opposing attorney, you'll be going your merry way with your case, and they'll just tell the judge, this is parental alienation. And
okay. I actually had this happen. This is like a month ago. So I was representing a father, and in our petition, we alleged parental alienation, right? As time goes on, all of a sudden, there's an emergency motion that's filed from the other side, and now he's being alleged to be the parental alienator. So what I do is that, first of all, you can't prove parental alienation absent a qualified expert that's going to have some sort of docket review, maybe have some sort of evaluation of the child or children. You can't just go into court. Attorney is not a therapist. The judge is not going to take what the attorney has to say. So to prove that, they're going to have to hire an expert to prove that. What I would do if that allegation gets brought up, I would take them through a rigmarole of discovery. I would send them interrogatories. I'd send them requests to produce. Give me all the documents you intend to rely on to prove your allegation of parental alienation. Give me all the statements, all the third parties you've spoken to that you intend to rely on to prove parental alienation. Give me all the experts and all the witnesses that you intend to bring to trial to prove parental alienation. So what you do is you call them out with discovery. And if they can't produce it for you in a timely manner and your case goes to trial, if they try to produce it for the first time, you object and you say, Your Honor, I asked months ago for this discovery. They never submitted it. So in that case, I would ask to strike exhibits. I would ask to strike the witness because they had an opportunity to give you notice so that you could have went in, deposed their witness, those sorts of things. So you really have to, when people are making allegations that are not true, hit them with discovery. And most pro se litigants don't understand the value in that, but that is huge. And if you don't know much about discovery, get onto Google and look it up. I've had pro se people do depositions and they were great. They were really good. I was like, wow, this guy really knows what he's doing. So like I said, that is the biggest thing. Once you hear an allegation that is absolutely not going to be substantiated, you call him out on that. Hit him with as much discovery as you can.
Well, that's excellent advice. I'm so glad to have you on.
Thank you, Maryann.
I'll probably have you on as a return guest at some point when you're ready.
Sure.
I know you're very busy. So don't jump off. Slam the Gavel's a podcast to help the public understand what really goes on in these family courtrooms. I am your host, Maryann Petri, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth. Please join us again here with Attorney Leslie and other exciting guests. Thank you again, Attorney Leslie.
Thank you, Maryann. Thank you.